Okay, I think we're live. Tell me if we're live. I don't really have a good live stream screen, so I need to find one. Because this starting soon screen is cool, but then it says starting soon. Maybe I can make one while I'm sitting here. Streaming screen. You guys just get to watch me do all this stuff in real time. Super fun, isn't it? Starting soon stream. Anyway, I wanted to come on. I'm sure that maybe some of you are jumping on now. I don't know how this works yet, but I wanted to answer some questions from yesterday's live stream and set some ground rules because if I'm going to come on here and answer questions, it's obvious to me now that there's some ground rules that we need to set. I'm going to have to also like set up some help. Some people have offered to be mods for the chat and things, and I'm going to have to set rules up for the chat, but I'm also probably just not going to pay attention to the chat too much. I'm going to come in the things that I want to answer. Obviously, I can't answer specific questions. This isn't legal advice, and I'm not your lawyer. I can answer general questions. I can explain the legal significance of documents in a general way. I can provide legal information about things generally, and that's what I think it's important to do here. But I can't provide legal advice on a particular situation. Now, the point of a class action is that a lot of you are similarly situated. So the thing is that legal information can be useful on a broad basis because you all are just sort of, I think the big problem is that a lot of you don't understand the legalese and what legal information can do for you. You don't necessarily need legal advice on a particular situation. You could apply your own kind of thinking about things. You could just get some legal information, someone to maybe help you read a document and understand just what it says, not to advise you on what to do about it, because those are decisions you would either have to hire a lawyer to advise you on or, decisions to make on your own. Okay, sorry about that. I don't know why that's doing that. I don't know how to make that stop, but thank you for subscribing. Now I've created a monster in Streamlabs where it does a little thing every time somebody subscribes. Thank you for subscribing. I don't know how to turn that off. Maybe I can press pause right here. Um, Unless we like it that it does that, but it does make some noise in my ear when when people subscribe, and I couldn't figure out what was happening on my computer earlier because people were subscribing to the channel. Um, okay, but there's some ground rules. First of all, I just want to answer some questions that were in the comments to the other video and clear up some misinformation that's out there already, um, and set some ground rules and make some requests of people. Who are out there who want to be helpful because there are a lot of people who want to be helpful here, and I appreciate that. And um, I I would appreciate assistance in helping me sort of reiterate the message that I'm sending when people are saying incorrect things about what I have said, because there are frequently people that will say, "Oh, Chancery Daily said this," and that's not at all what I've said. And I can't be everywhere all at once, and what I can't have is people misrepresenting what I have said all over the internet. And so one of the dangers of me trying to do this is that I will have people misrepresenting what I've said all over the internet, and that's just not really safe for me. I don't feel comfortable with that. And so I think it's honestly one of the reasons why people don't put themselves out there like this. And probably just because there's no incentive to do this. There's no financial incentive for me to do this. There's a lot of downside risk to doing this. The only reason that I'm doing it is because I give a fuck about you guys. I think that you deserve to have this information. I don't think that most of you the cost of hiring a lawyer would outsize most of your positions in this trade. It's nonsensical that it would cost so much. It's just the system is a little fucked that way. And so I think that something's broken there. And don't I don't think that's right. Like in my heart, I don't think that's right. So I'm trying to do something to remedy it. But I'm operating in a system that's kind of broken. So I need you all to help me handle that, which the way that you can help me handle that is to correct anyone who is misrepresenting what I'm saying. So one thing that I need you to correct any misrepresentations about is that I am never providing anyone any legal advice. So if you ever see anyone saying, "Oh, Chancery Daily advises that you do this," even if it seems like something benign, I am never advising you to do anything. Even if it seems like something innocuous, like Chancery Daily says you should blah blah blah. It's just it's really not that I'm ever saying that you should do that. Sometimes I'll say what I would do if it were me is X, Y, or Z. But you all have to make your own decisions about these things. It's really important that you don't consider what I am telling you to do advice that I am giving you because it's not I I can't be giving you legal advice. I can't be giving you legal advice because I don't know your individual situation. So I literally can't be giving you legal advice. It's also not appropriate for me to be giving you legal advice. So I want to be really clear that I'm not giving you legal advice. And this is the bind that people are put in when there's a whole mass of people out there that have incorrect information or that are uneducated about something. And beside the fact that nobody has any financial or other incentive to go out there and help you all, there's also a risk that I get made to look like I am giving you legal advice when I am not. So I need you to be very careful about how you speak about what I am saying and about how you let people speak about what I am saying because I am not providing you legal advice. I am trying to help you understand what documents say, and I am trying to help you uh, read words on paper because I understand that they're very confusing. And sometimes it's just as simple as I'm trying to show you what page in a document something is on. Like last night, the big thing that I really showed you was that you could scroll down in a very long document to see where your name was in a group of names and to see if your name was in the appropriate category. That wasn't legal advice for sure. I'm 100% certain that I was not providing you legal advice, but you could make it sound like I was instructing you to call or do something or whatever. It's just so much better if you do not ascribe those kinds of things to me. You all have to be fucking grown-ups. You have to be big, tall. You don't have to be tall. I'm not actually very tall myself, but you have to be big people, right? You have to be mature adult humans here. You have to take responsibility for your own actions. You can't be relying on me being the one that's telling you to do something, okay? You have to be listening and then making decisions on your own. That's what this is. This is information that you are then acting on, okay? You have to really get that into your minds, and you have to not only get that into your minds for yourself, but if you hear other people misrepresenting what is going on here, you have to correct them about it because I can't be everywhere to correct people about what's going on. So please take up that banner for me because otherwise I just won't be able to continue helping you because it will be mischaracterized what I'm doing, and that's not safe for me to do. So, um, please let me share my knowledge with you about the basic fundamental fucking way to read a document and not have it be misinterpreted what I'm doing. So um, that's that. Also, I don't work for the court. I want to be clear about that. I My dear friend with whom I worked at a firm in Wilmington with for a long time. He started the Chancery Daily, which is a legal, basically a trade publication for lawyers. We publish an incredibly dense, incredibly unreadable, like 10,000 word publication every day that's for lawyers, for litigators in the Court of Chancery. I'm the editor in chief of that publication. He started that 10 years ago. We have covered everything that happens in and out of this court for the last decade. Every single document, basically, in and out of this court, we read. I read every single alert every day that goes in and out of this court. I know everything that happens in this court. That is my day job. That is, and in that publication, we served lawyers. And then I last year started covering the Twitter versus Musk matter. And in that case, we had the opportunity to start bringing corporate law to a broader audience. And Kyle, my partner, my business partner here, and the owner of the Chancery Daily, he's always wanted to serve a broader population. He's always understood that corporate law impacts people widely across the world, across the country, across the political and economic spectrum. And that people just for some reason never really cared about it. And the Twitter case was a perfect opportunity to share that corporate law actually did impact people, and it was an opportunity to get people interested in it. And so I started our Twitter account last year, and it became a big deal, and it got the message out there, and people got interested in it. And it was a good opportunity because for whatever reason, Elon Musk is like a thing people are always really interested in, no matter what it's about. And Twitter was a way to get, people were interested. It was on Twitter, about Twitter, and Elon's a big Twitter account. And so it was just this perfect storm of opportunity for people to be interested in corporate law. And so we started, that was our first time really talking to lay people about corporate law. For the last better part of the decade, we had only been speaking to lawyers, to litigators. So this is new for us to be speaking to just lay folks, normal, not lawyers. And we've always wanted to do this. It's always been a vision for the mission. And it's an amazing opportunity. And this case is like the culmination of that opportunity. This case is a perfect example of what is available when it's a perfect opportunity. It's a perfect example of the need that is out there, the way that corporate law impacts people's real lives, and also demonstrates the need that people have to understand a lot of the nuances of corporate law. And um, it also shows a lot of the difficulties of articulating the complexities of corporate law to the lay public. So look, you can see me. I'm just like, struggling to figure out how to fucking use YouTube and like talk to you all and and do all of this because it's all new for us, right? We're still running the main publication. We still have to earn a living. We have a staff. We have, there's three of us. We're all Penn Law grads. We write the main publication. That's a full-time job for me. That's what I do all during the day. All this other stuff covering this AMC case nonstop is basically, normally we would just cover the case once it was over. We cover every case, but usually only once it's a written opinion or something. It's very bizarre to be covering this case obsessively throughout the whole, every minute of every day. Um, so the only reason that I'm covering AMC so uh, immersively is because I started writing the Substack. We call it now our sister publication. It's just me basically ranting on the internet. Like, so in our main publication, we publish the Chancery daily, not surprisingly, every day that the court is open. But like I say, that publication is very staid, stoic, kind of lawyery, legally, much more buttoned up. It's not very commentary like I think would be it's probably pretty difficult for some lawyers to read. Um, it's a different type of animal. It's meant to digest every single written opinion that comes out of the court and to be a sort of legal resource. So there was no outlet for me to just kind of vent about what I thought about things. So I started writing the Substack last year as a way to talk about what was going on with the Twitter case, also as a way to just communicate with all these I suddenly had 20,000 followers on Twitter who were interested in all the intricacies of what was going on with the Twitter case. All the Twitter employees started following me. They wanted to know what was going on with the case on a day-to-day basis. They were personally impacted by what was going on with Elon and the merger. It was just this whole new like way of interacting with a case that was totally different from anything we had ever done before. So I started writing the Substack just basically on like nights and weekends. It was just an on the side kind of thing. And so that just became an outlet for basically handling popular kind of cases and talking to a different audience. And so then once that was over, I covered the Fox Dominion case on the Substack. I covered, just a bunch of different sort of popular type of topics, things that Elon is involved with, many cases in the Court of Chancery. People always want to hear about things that are going on with Elon. Um, Basically, I just cover things on demand on the Substack that people. There are lawyers, lots of lawyers who subscribe to the Substack, lots of financial people, lots of just regular people who are nerds or wonky or uh, just geeky or just interested for whatever reason who subscribe. And then the AMC matter started happening and it just started getting so much attention. The court started getting so burdened by all of the attention that, one of our we feel like our role, we're all three of us are Delaware barred attorneys. We also feel like as officers of the court, our job is to, um, try to take the load off of the court, whatever degree we can, in sort of helping to mitigate some of the burden of just the normal requests that might go to the court otherwise for like, can we see this complaint or this document or this whatever, just silly things that the court would otherwise have to manage constantly. If we can offload some of that, like last year in the Twitter matter, we made a full docket online that people could access. So that they could just go and see the primary source documents. I'm a big believer that people should be able to look at the primary documents themselves. They're hard to access in the Court of Chancery. It's a sort of clandestine. Uh, Delaware has a reputation for being as not as transparent as I would prefer if I had my hands in the gears of the technological sort of machinery and I could just make it the way that I want it to be. So So, yes, my Substack is a paid newsletter. I will tell you though, I write a ton of stuff on my Substack that is in front of the paywall. So you can feel free to subscribe to the Substack without paying. You can just subscribe and click on the don't pay version. I wouldn't suggest that most of you who are interested in AMC pay for the paid version, because I assume that you'll just not be interested after this matter. And most of the time when I write about AMC, other than some of the super, super deep dives, I generally end up feeling guilty and just putting it in front of the paywall because I'm a sucker and I hate keeping information from people. So it's worth it anyway. Regardless, I frequently put there's a fair solid bit of number of posts that go in the front of the paywall. So if you're on the list, you'll get emails. And if you're on the list and you're not a paid subscriber, you still get like previews of the paid posts, and then you can choose whether you want to subscribe or not. But in any case, you'll get a bunch of content that is pre-paywall. So you can subscribe for free and you get a bunch of content, but you don't have to subscribe at all. I'm not here to shill my fucking newsletter. I don't give a shit about that. I don't assume that anyone here is really interested in that content. I don't, I, I'm not here for that. So what I'm trying to do here is answer the question. Someone in the other video said, I work for the court. And what I want to explain is that I don't work for the court. I don't want there to be some misunderstanding that I work for the court. So that's what I'm trying to clear up. I'm trying to explain who I am and what I do and why you should make your decision about whether you want to listen to what I have to say. Um, I think that pretty much covers it. I'm I'm I was a practicing attorney. I he couldn't stand a lot of aspects of the practice of law. And so I started my own sort of legal consulting business about a decade ago. And then I ended up, like I say, one of my really good friends from the firm, Kyle, started the Chancery Daily about the same time. And he literally for the last decade has been nagging me to, I was subscriber number one to the Chancery Daily because I was sort of helping him get things started. And then he's been nagging me to come and work with him on it for, well, for until I did. And so anyway, I he finally got me. Um, but the rest is history. So that's who I am. That's what's going on here. Why I'm here, I mean, God knows. Like I said yesterday, somebody posted a comment to my video, and I shouldn't be as worked up about every stupid comment that comes on my videos, but it's like, they're like, why are you here? Are you being paid by someone? It's like, dude, if you can't listen to the video, I don't know why you would comment on it. But I think I made pretty clear about why I'm here. I'm here because I can't I can't tolerate all the misinformation that's out there, and I just want to help clear some of it up. So I think that's about enough of that. Um, those are some of the sort of the ground rules. I guess I'll sort of set them out later, but I basically wanted to give you that background so that you can go off and help me sort of clear up any misunderstandings about what I'm doing here, who I am, whether I'm giving legal advice to people, which I'm not. So if you hear anybody misrepresenting any of that stuff, I would really appreciate it if you would help me out because, like I said, I can't be everywhere. And so if you can just kind of help me keep people on track with who I am, what I'm doing, and all of that, when you see people misrepresenting those things online, I would really appreciate it. So, if you're in the wrong category, there's people asking a lot of questions about this document, and I again failed to put the link. So the comments from the live feed last night weren't, I had the setting, I didn't know how to do anything last night because I was just testing that stream, and I didn't know how to put the link in the in the description because I'm so new. Um, but I will put the link in the description. I think I figured out how to do it now. Um, the way that you find the document is to go to the AMC Investor website. You go to the fourth document down, the corrected transmittal affidavit of Thomas Curry with exhibits. And then you go to the like 500 and some 550th page or something, at least 500 and something page. You go to the 25th exhibit, and then you look at the exhibits to that exhibit. They're nested exhibits. So you go to that document, corrected transmittal affidavit of Thomas Curry with exhibits. And I showed you in the other video, I think it's at minute like 41 or something. Somebody in the comments showed where it's at. I show you how to exactly get there. And then you find yourself on the list. Unfortunately, they didn't OCR that document, so you can't just search for your name because the list itself is not OCR'd. I was going to try this afternoon to put up an OCR'd version on a different website because, God forbid, they had done something useful. Um, if I can get to that, I will. But anyway, that OCR might not be perfect either, so you should probably rely on your human eyes and your page 543 starts the list. Thank you. So you want to go to that document, you want to see where you're at. Now, someone said in the comments just now, you don't understand where you are as shareholders. And I understand that feeling. Because there's even a confusing sort of aspect to this idea of being put into groups about having requested an opt-out or not. And it's somewhat hard to explain. So I can imagine if it's hard for me to explain, it's going to be hard for you to understand because If it's hard for me to understand, that means it's going to be very hard for you to understand. Um, but the court, so when the court ruled originally on the settlement notice, the parties came to the court and said, we've agreed to a non opt out settlement. And the court said, well, wait a minute. You don't get to decide that exactly. She said, I get to decide that. You don't get to say that for sure, for sure. You have to change the language in the notice to say that you have provisionally agreed, or that this is provisionally designated a non opt out settlement. So there was some change in the language of the notice that the court required. And I can go back and look at the exact change that was required there because it was nuanced, and it's important what the nuance is because it was a big kind of deal because historically these settlements have been non-opt-out settlements in the Court of Chancery in the context of a case that is requesting injunctive relief. And this gets incredibly complex on the historical context and the case law and the legal aspects. So I'm certain that I can't do it justice in a way. It cannot be sort of reduced to a a 5-minute summary here. But what I can say is that when you're put into these categories here of non-opt-out, opt-out, you are not opting out of the settlement or not opting out of the settlement. All that's being said by these categories is whether or not you said you wanted to opt out or not. Because this only settlement that is in front of her for approval is a non opt out settlement. And all that she can do in this round of approval or rejection is approve or reject the settlement as it's presented to her. Someone actually mentioned this in the comments, and bravo to them because it's a fine point of law. But she is not able to what's called blue pencil the settlement at this stage. She isn't able to blue pencil the settlement. What that means is she can't, for some reason, they call it blue penciling. She can't take her blue pencil and say, oh, I'm going to change this from an opt-out, a non-opt-out settlement to an opt-out settlement, and then just force it through as an approval. Because that would obviously not work, right? Because then all those sort of questions that you all are raising, like, but what the fuck? I didn't know that I could opt out or not opt out, or did I opt out, or was I supposed to say explicitly that I wanted to opt out, or I didn't know I was supposed to say I wanted to opt out, or no one told me I had the right to opt out, or all these questions that you're raising would come to reality, like they would be problematic in the ways that you're thinking they are problematic. If she decides that she thinks that there has to be an opt out class here, which is one of the things that Rose Izzo's objection is arguing for, and which is one of the things that if you're in the sort of list of people who said I want to opt out, you're implicitly being put in a category of people who are sort of arguing for that kind of thing. If she finds that there is an opt-out class required in this case, we would have to have an entire new round of notice that gave everyone the ability to opt out properly. We would have to have an opt out period. Okay? Does this make sense? This is not so So you're only being put in these categories here to say this is an indication of how many people sort of suggested that they thought there should be something like an opt out because they said that they wanted to opt out because perhaps they didn't understand that there wasn't really an opt out explicitly on the table at this moment, but they said that they wanted one anyway. So there isn't technically an opt out on the table right now. An opt out is a possible outcome. Now you have to listen carefully to what I'm saying. These words are very particular. I am not saying that an opt-out class is a likely outcome. Are you hearing me? Because this is important. I do not want you to run off onto the internet and say that I'm telling you that there's going to be an opt-out class in this case, because I am not saying that. You have to listen to words very carefully or you're going to be misled, and I am not here to mislead you. I am saying that one possible thing that could happen in this case, not that it is likely, not that it is going to happen, but it is a possible outcome, is that the court could say, I don't find that a non opt out class is appropriate here. You have to go back and I reject this settlement because I don't find that I find that a non opt out class is inappropriate. Now, the thing is, she can't say, I force you to settle with an opt out class. The thing is that at that point, all she has really done is rejected the current settlement. And at that point, a whole new process begins. At that point, what we have is a rejected, this settlement is all that is currently on the table. At that point, we have a rejected settlement, and then we have a whole new, if we're in like a flow chart of possible universes that we move into, we have a whole new universe, possible set of universes that we move into. So when you're worrying like, well, was I supposed to opt out or not opt out? You don't need to write to the court and say, oh my God, I want to opt out. You don't have to worry about if I opt out. You're not going to be actually opted out of anything or opted in. If the settlement goes through as is, everyone's going to be opted into it because it's going to be a mandatory opt-in settlement. It's not going to have an opt-out option. If she approves it as a no opt-out settlement, everyone's going to be opted in because it's going to be a no opt-out settlement. That's a possible type. That's the most common type of settlement in the Court of Chancery. When every stockholder is similarly situated and stock is basically a fungible asset, it's a very common type of class action to have a class action settlement without an opt out. So you don't have to I would not personally, if it were me, I would not obsess over whether I was like my opt out or not opt out. Those are not meaningful distinctions because no one is actually getting opted out or opted or not opted out at this stage because we either are everyone is everyone is going to be opted in if the non-opt-out settlement is granted, though as is. If she approves a settlement, everyone's going through the gate. If she denies the settlement and grants an opt-out right, then everyone is going to be given the right to opt out. Even the people who said I already want to opt out, presumably everyone is going to go through an opt out, an actual opt out, an official opt out process. All that you did by saying, hey, I want to opt out in this round was to sort of show your support for the concept of an opt out settlement. So I don't know if that makes sense, but I hope that it helps a little bit. I wouldn't worry. I would not worry with whether you're on the no opt out or opt out list. It doesn't have a practical impact. And Rose Izzo's objection is a much stronger argument than anyone could have made by requesting an opt out for the opt out right. Rose Izzo's objection makes a very, I mean, I think the strongest legal argument for an opt out, which would outweigh 1,000 of you having requested an opt out, I think, because it's strong and backed by actual legal arguments. So my just sort of take would be that I don't think that it fussing over whether you are on the opt out or non opt out list. You could send an email and say, look, I'm on the wrong list, but I, I don't think it's going to have any practical impact. And it's not going to have a practical impact in the sense of putting you in a differently situated position, whether you are on the non opt out or opt out list. You don't need to like decide that it's not going to actually opt you out or opt you into the settlement. Either everyone is getting opted in if she approves the settlement, or everyone's going to have an opt out right if we have to go through if she rejects the settlement and says, I think there should be an opt out right, and then the parties actually agree to an opt out right settlement, we go through this whole other process where there's some opt out period if we even make it that far, if the parties decide not to litigate this case somehow, or I don't even know what happened. That's like a whole other bowl of wax. So there's a lot, a lot going on there. Um, I hope that that helps a little bit. I want to answer some questions about the postcards. Okay, the receipt of the postcards, I understand that there are passionate feelings about the notice and whether or not it was sufficient. I want to say that I hear your concerns about it. I want to say that I am not minimizing the concerns about it. I also do not want to get in the middle of that argument right now because I want to answer a question about the practical impact of the notice issues. Okay. So let's set aside the issue of whether or not notice was sufficient because that is something that the judge is going to decide. One of the things that the judge is going to decide at the hearing, no, she's going to decide it after the hearing, but one of the things that she's going to be contemplating at the hearing and then deciding in her opinion thereafter is whether notice was sufficient and satisfies due process. So I'm going to set that issue aside for a moment because I want to disambiguate it from something else that people are concerned about. There's a whole thing to discuss about that. I just want to set it aside for a second because I want to tell you that the way that notice is handled, the postcards, there were various forms of notice, okay? There were postcards, there was publication notice, there was 8K notice, there was a press release notice, there was Twitter notice, sometimes there are postcards sent, sometimes there are not postcards sent. There was emails to some people. I understand a lot of you did not receive postcards. What I want you to understand about that is that there's a due process issue. That is one thing that the judge is going to be deciding whether or not that was sufficient. Let me set that aside for 1 second. There's a separate question of whether or not a lot of you are concerned that whether or not you received a postcard has something to do with whether or not you will receive the settlement consideration. And I want to tell you that those are two separate processes. So there should not be any correspondence between whether or not you received a postcard and whether or not you will receive settlement consideration. As for people who received their postcards late, all that I can tell you is what the Vice Chancellor has said, which is that you can submit an objection after the deadline, and she cannot promise that it will be heard. I don't know what else to tell you. Like, you should do what you feel like you need to do. If you Like I'm not going to advise you to send a million objections in now, but there have been a lot of objections lodged in this case. I, if you received your postcard late, you could, you can, I don't know. If it were me and I was super passionate about it, I may, like, I, I don't know. You could send an email and say, I got my postcard late. Do not send an email to the court, for fuck's sake. All that you are going to do if you keep calling the court and notifying the court about things that are inappropriate to notify the court about is drive the court, and you're going to reduce the amount of resources that the court has to actually consider the merits of this case. So please do not burden the court with things that are not relevant to the actual, like, that are not appropriate for. Handle this case the way the court told you to handle this case, which is to send your everything to the email address that you were told to send it to, which is to whatever, the email address at blbg.com. Okay. If you want to send a notification that you didn't get a thing, send it there. If your name isn't on the list and you sent a thing in, then send an email there. And if you don't get a response, then send a follow up. Like, just be adults. Like, you don't, you can involve the court once you have done your diligence, but to just spam the court with things is so inappropriate and so wasteful of its resources. There is a way to do this that is useful, and there is a way to do this that is just incredibly self-defeating in a way that I can hardly explain, is so, so self-defeating. Um, so I just I just want you to understand what is useful and what is not. Um, okay, so I'm trying to look at some comments and um, so if you did not receive a postcard, that does not have really anything to do with whether you will receive settlement consideration. And I'm trying to get my arms around what the process for receiving the settlement consideration is much more like receiving a dividend. It's much more highly regulated. It's a much different process. Now, will some of you, I mean, if you have FTX AMC tokenized stock, are you still going to be fucked? Yes, probably. But if you have FTX AMC tokenized stock, obviously you probably didn't get a postcard either, and you probably don't actually own AMC stock. So, um, hopefully you know that by now, and I'm not the first one to tell you that. But I'm just trying to see if there's any other things here. Let me let me just look at the comments on the other video. So I think that I basically addressed everything that I wanted to address. Um, so I think that you should, I know that it's difficult to, I know that there's like, everyone just got this postcard thing. Just, I know that the postcards are a big a big thing. However, there was just a case last week where the court approved notice by publication only, which means not a single person got a postcard, not even a record holder, not no one got a postcard, not even people who own stock like through the company. Like no one got a postcard. No one got a letter. No one got anything. Um, so, you know, I think it's problematic how it turned out that everyone got so fixated on the postcards in the sense, not in the sense that people think that they deserve due process because they do, but that people like lost the thread of what was important. Um, on the other hand, like a, a an historical number of objections got lodged in this case, and thankfully a one objector had counsel, which makes a difference. And I think, you know, entered some objections that have, you know, for the people who had objections that they were concerned about, I think that objector represented those objections as best as you could have hoped if you were one of those objectors. For the people who were in support, there were some, there was at least one strong letter of support written. Um, I don't know. I think things pretty much shook out in the wash, so to speak. I think that there was a lot of n noise and still some signal there. So I'm not really sure. The point of a class action is that it's a representative action. The point of a class action is that everyone is similarly situated. And so one person's idea of the case, one person's objections to the case aren't going to be dramatically different from anyone else's. So a lot of people are passionate in this case on a very like unique and individual level, but the sort of concept of class actions breaks down if every single one of 3.8 million people have to be individually notified and conscious and present to the idea of the class action. It would make it effectively impossible for a company to ever settle a class action. And maybe that's like your position that a company should never be able to settle a class action. Some people probably truly believe that. Um, but that's sort of an ideological position, like about class actions and their utility. Um, and so there are a lot of bigger issues here, like everything about the AMC matter. There are so many bigger, broader issues that are way bigger than the movie company or the stock or the trade or the anything. Like everything is just outsized. Everything is so much bigger than what it's even about. Um, so I I don't know. There's a lot to unpack in a lot of what's going on here. Um, so the typical timeline, I've talked a lot about it online, but I will just reiterate what I've basically said before is that the typical situation in a settlement hearing is that the judge will rule at the hearing. However, in this case, we have heard from Vice Chancellor Zern in writing that she said in her, I'll pull it up for you right here, in her letter to stockholders, the judge has said that The judge has said that she will not rule at the hearing. She has said that she will rule sometime thereafter. So, first page of this letter here, she says, I intend to hold the settlement hearing on June 29th and 30th. That's in bold in the first paragraph. I write to provide you this letter she put out on, I think, May 1st or something. I write to provide you with more details on the timeline in the hearing and the instructions you must follow if you intend to object to the settlement and appear at the hearing. This letter explains that the court will not be issuing a ruling on the settlement at the hearing, but will be issuing a ruling at a later date. So that is all that we know about. That's the only official word that we know from the court about when she will be ruling. What we know from a historical, point of view about what the court's general practice is, that there are two different data points. One is that generally, in a settlement context, the court does rule at the hearing, which is why she's saying that's not what she's going to do here. She's making it clear that she's going to not do the normal thing, which is she would rule in a what's called a transcript ruling, which is she would just rule from the bench. But here she wants to obviously provide a written. It's going to be a much more complicated ruling here. She's got to address all of the objections. There are 2,850 of them. There's normally maybe 0 to 1 or 2 at most. So she's got a vastly different situation here. She wants to obviously have a written ruling so that people can have it to read and to review. There are a lot of reasons why this needs to be a written decision, not an oral ruling. So we know already that's not going to be the standard sort of transcript ruling at the hearing. So then the question is, when is it going to happen? The answer is at a later date. Um, the other guidepost that we have is that, Court of Chancery decisions generally are issued. Their guideline is to issue decisions within 90 days of the last day of the month in which they are taken under advisement. Technically, this would be taken under advisement on June 30th, so that would mean July, August, September 30th would be like the last day that technically the guidelines would say you could issue a ruling on this. Of course, the guideline is a guideline, not a rule. And this year, Vice Chancellor Zern's rulings have been anywhere between, I don't know, 80 and 115 days or something out. Now, I don't assume she'll take that much time on this because she has technically been able to have some of it under advisement. She will have the report and recommendation from Corinne on the 21st of June. So that gives her a little bit more time with it. She has the reply briefs now. She had the original brief as of the 5th. But it depends. It depends what happens at the settlement hearing. It depends how many new issues are raised. It depends how much interaction there is with counsel. It depends how burdensome her other workload has been over these past few months. Which it has been incredibly burdensome, I can tell you. So um, the answer is that I can't tell you. I'm not going to speak for her, obviously. And that those are some of the outer guideposts that I can give you. Um, if I were her, I would obviously want this matter to be wrapped up, but Vice Chancellor Zern is incredibly principled, and I know that she will also be considerate of the issues that AMC has raised about capitalization. She's not going to allow the company. She's obviously been incredibly expedient so far. She has issued rulings on everything that she's had under advisement in like several days when they have been ripe for her to decide them in this matter, which is extraordinary. She has been incredibly responsive. She's the one who pushed the parties to even get this done when they were dragging their feet. Like she has been more responsive in some sense than the parties were to moving this forward. When they were saying, "Oh, we've got to do this because the company needs it," she was like, "Okay, well, come on, let's do this." So, um, she's, definitely on the ball and not going to she's also not going to not give it the time that it's due. And y'all submitted 2,850 submissions that need to be reviewed and considered, and you all want due process. And so there's a balance there. So I cannot tell you how long it's going to take, um, but I can tell you those are some of the data points that we have about, what it could mean. Um, I do want to just cover briefly in this letter also what the next things that are coming up are. So first of all, if you submitted a letter, look, I'm not going to give you legal advice, but I can give you human, just don't be a dumbass advice. If you submitted a fucking objection and if you're not on the list, what should you do? I don't know. Don't write to the court. I would send a fucking email to the people that you emailed the objection to and say, hey, my name isn't on the list. That's what I would do. I'm not advising you that legally. If they hear me saying that, they're probably going to be annoyed with me because they're probably going to be annoyed by getting other emails. But tough shit, if they didn't put you on the list and you submitted your shit properly, then you should email them and say, dude, in a very nice, polite way, say, dude, what the fuck? But don't say it like that. You should say, dear sirs and madams, messieurs and mesdames, folks, I submitted these documents on whatever date. Attach a copy of the email, attach a copy of the documents, provide as much documentation as you can, provide the literal, like, pull the email over there if you can. Just make it as simple as you can. Do not be rude. Do not be abrasive. Just be polite, be respectful, and say, I provided these documents. I reviewed the affidavit of Thomas Curry at Exhibit 25 of whatever, and I do not see my name in the appropriate list. Please advise. That's what I would do. Look, it's not legal advice. It's just like, what do you think you should do if your name isn't on the fucking list? I'm telling you, don't call the court. Do not call the court about that. That's not appropriate thing to call the court about. What's appropriate to do is to fucking be an adult and follow up with the person that you sent the thing to, and then who said you didn't do what you said you did. Okay, so just like that's what I would do. If you The list of in-person objectors has not been released. However, if you were an in-person objector person, you were supposed to have been notified about having your shit redacted. I'll cover that in a second. But let me do this one thing before. Um, I'm just looking at some. Can somebody put the link to the lists in the comments, please, for me? Because I can't figure it out. If somebody has it there, please could you post it? Um, okay. Um, so okay. So I just want to cover that the next thing that's going to happen is that the special master is going to file her report and recommendations on the 21st. And she is going to, and that should be posted on AMT's website. They should actually fucking update the website this time since they got smacked down by the judge last week. We'll see if they do, but they did get smacked down by the judge. So, um, the 21st, she will actually publish it, I'm sure, before the end of the day, so we don't have to deal with the nonsense of getting it the next day. So the 21st of June, what you'll want to do is review the report and recommendation. Now, I have no idea how she is going to handle 2,850 objections meaningfully in a report and recommendation. She's obviously going to have to do something like what the plaintiffs did and bucket them to some degree. She's going to have to do something like what they did and say, oh, some people followed a form of the Gunter objection. The plaintiffs were supposed to give us a list of who they said followed the Gunter objection and who followed the form objection, and I don't see that list anywhere. I assume that maybe the special master will actually do it. And then by June 28th, so okay, the 21st, you're going to get the report and recommendation. By the 28th, you you have 7 days to file exceptions to the report and recommendation. But you have to listen to something. You have to file the exceptions to the report and recommendation with the court. And I don't actually know, like, I guess you have to file them. You have to, it says exceptions must be received and docketed by June 28th. You all have docketed some things before, and I don't, I know some of you, I know Eitan and Al and Jordan and Brian have uh, SRI file and serve accounts, but I don't think the rest of you do. So I assume the rest of you are docketing things, who docketed things inappropriately early on in the case when you were sending them to the court instead of sending them to the plaintiff's counsel email like you were supposed to. Uh, we're docketing them by sending them via snail mail. I mean, some of you were originally inappropriately emailing them to the court, but uh, you need to learn. You should take time now to figure out what it means to docket something to the court. Can someone please post the link to that document in the comments, or is it not working or something? Maybe it's like, maybe it's not posting the link because I don't see it. Um, sorry. Um, so you need to figure out what it means to docket something if you're planning on docketing something, because otherwise a bunch of you are going to get caught not being able to docket something by the 28th, because docketing something is not like shooting off a fucking email. You're going to have to actually mail it. So do you see where it says, for instructions on how to submit exceptions and the required filing fee, please refer to the Register and Chancery's April 14th letter. I'll find a copy of that and get it posted somewhere. It's probably on FKS Firm's website. Maybe they've done the best job so far of um, having actually all their shit together. So let's see. April. Nope. 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 I don't see it. Um, I'll try to find it and get it posted somewhere. So you should figure that shit out now if you care, because you're not going to figure it out last minute. And it's not the same as emailing it to plaintiff's counsel, and you're not supposed to do that. And it's a bigger deal and it should be more official. And you need to actually, it's not just like shooting off a letter to file exceptions to the report and recommendation. You need to actually have a legal basis. You shouldn't just file 20 of the same thing. You shouldn't just do it to like file the same one as Bubby Gunter. You should just like let Bubby Gunter file one and consider that the one that's canonical, because you don't need to be submitting a million exceptions to the report and recommendation of the special master. And frankly, if the special master decides that, your objections are don't hold water, then I don't know. Maybe she's probably not wrong. I mean, but you're welcome. You have every right to file exceptions if you feel like she is wrong, but you should probably have a legal basis for that argument, not just, I think she's wrong. I mean, I would highly recommend that you have a legal basis for any argument that you're making. Um, so, and if you send it USPS priority, you need to have it arrive by June 28th. And you have from June 21st to then have it arrive by June 28th. So you need to actually look at a calendar, like big adult grown-up humans, and make sure that you can actually do all of this, or else you're going to be whining after the fact that you didn't have enough time or that it was a holiday or some shit. And you just have to actually plan these things out. You have to prepare in advance. This letter has been out here since May fucking 1st or something, okay? If I can read it, I'm actually pretty sure this letter it was written by the vice chancellor. This is not something she ever does. This is not a normal thing. This was written in order to be read by you all. This is written in fairly plain English. So you need to actually be reading it. And I'm sorry they keep removing the link. I guess it's because it's like a weird, it looks like a spammy link. Um, so I'll find another way to put it in the description. Um, so maybe I can go on to YouTube and tell them to stop removing the link. Um, you just have to plan, okay? You have to plan better. Like you have to, oh God, oh no, oh no. Inception. Sorry, I was listening to myself talk. Um, okay, so yeah, well, the letter was only recently published by AMC, but it's been on all the other, well, is that even true though? Wasn't this letter published by AMC a while ago? Because the new stuff was only recently published by AMC, but this document was recently published by AMC. The letter to stockholders. So if you go to AMC Investors website, you'll find this document. And then, but this letter to stockholders should have been posted by AMC a long time ago. If you go to the AMC investor website, scroll down to the bottom of the page where it says stockholder information, and then you'll find it there. Okay, there was something else I was going to talk to you about. It's something in the other letter. What was it? This one? Okay, yeah. So if you submitted an in-person form, I covered this yesterday, but I don't know if y'all were here. If you submitted an in-person form, there's two groups of people right now who objected. There's groups of people who objected and groups of people who objected and submitted an in-person form that was postmarked by May 31st. I guess there's technically sort of, then there's a couple of exceptions to that, which are like Bubby Gunter, Rose Izzo, um, the form objection, and Brian Tuttle. I think those are the only ones whose objections were um, exhibited to the reply brief. So those objections are already like made public, I think. Um, let's see, we can go check that after this. But if your objection is not yet exhibited to the reply brief and you want it to be public, now you have to decide this for yourself. Somebody asked on the other stream, why would you want it to be public or not? I don't fucking know. I mean, that's I can't look, you have to use your brains on this stuff. I can't tell you these things. Even if I were your fucking lawyer, I couldn't tell you that. I mean, I don't know. Do you want your point of view to be public or not? That is just something you have to decide. There's really no, I can't even think of, it's just that you all have weird, like, fetishes about this stuff. You have weird desires. Some of you are like obsessively online. Some of you are completely committed to having every one of your thoughts about this matter be incredibly public facing. Some of you don't want anything about yourselves to be known. You're incredibly anonymized. Some of you want your everything to be very well protected. Like, so you all have very competing ideas about what you want for your identity and your thoughts about this case, right? You have all manner of different needs and wants and desires around this. I have no idea what you want, but all I'm saying is there's a protocol that they're going to follow, that they are going to use to either unseal your objection and or redact your personal information or not, and you should know what that is, and you should decide what you want to do about it. Because some of you might be desperate to fucking have your objection public facing, and some of you may be desperate to have it not. I'm totally straight talking through it. So what was supposed to happen, and I am 100% not sure this is happening, but what was supposed to happen is that if you had submitted your in-person form by May 31st, postmarked by May 31st, you were supposed to have been notified, presumably sometime around June 7th, the date of this letter, that you had 10 days to submit a redacted version of your objection that redacted any personal, confidential, or sensitive information. And then you were supposed to have been notified, hey, you have 10 days to give us a redacted version, or else your objection from all that group of people was just going to become unsealed, because the presumption that's on the earlier page here is, well, look, these people who are in-person presenter people, number 12, number 11, number 12, number, I mean, no. Okay, number 8. The public interest in objections is to know the topics raised and to be discussed in court at the settlement hearing. So they're basically saying there's a public interest in knowing what's going to be discussed at the settlement hearing. And so we want to know that. We have there's a deeper interest in unsealing the objections from those people who are going to attend the hearing. And my other assumption, which I guess maybe isn't explicitly laid out here, is that, look, if you're planning on attending the hearing, you can't be that obsessed with your privacy, because you're going to show up in person in Wilmington and show your face and presumably state your name on the record and swear your oath and everything. So like you can't be that worried about it. So I have not heard that anyone has received this notification yet. Now, what I don't understand is, does that mean that the 10 days is still ticking? You would assume not, but who fucking knows? So maybe this is the notification. I don't know. Maybe they're gonna, I don't know. I don't know. But just like use your brain. If it were me and I read this paragraph and I was one of these people, and I would maybe shoot an email and say, hey, uh, again, not to the fucking court. The court has nothing to do with this. Don't involve the court. But I would shoot an email to the BLBG folks and say, hi, I submitted my in-person form yet and I haven't received my notification. Just wanted to, here's my redacted, like, again, make it as easy as possible. Don't just be a fucking pain in the ass. Like, I don't understand why everyone has to make this so difficult. It could just, the process could be easier, right? You either want your shit redacted, so provide them with a redacted uh, form, or you just don't care and you want it unsealed. So you could just shoot them an email and say, hi, I'm so and so. I don't have any problem with my information being unsealed. This is my name and address. Don't be a fucking pain in the ass and be like, I'm not going to tell them that I don't want my information unsealed. Just shoot them an email and say, it's fine. I'm not concerned about it. You can unseal my objection as is, or you can unseal my objection, but I want my address redacted, or here's a redacted version of my objection with exactly the shit that I want redacted. If you don't know how to redact something, use Adobe Acrobat or even Preview in Mac or there's probably a redaction tool that's free on the internet. Get a friend to help you. I'm sure there's a bunch of free Googleable tools if you need one. So, like, don't be difficult about this shit. They are dealing, look, I know you don't have any sympathy for the lawyers. I get it. I understand. But like, also, why are you going to make it more difficult to get what you want? If you don't want your public information, your private information to be public, then make it as easy as possible for it not to get fucked up. Like, don't be a fool about it. If you want your privacy protected, then make it easier to have your privacy protected. If you want your objection to be public, then make it easier for your objection to be public. Don't be a fucking pain in the ass and just try to futz up the process. Just simplify this shit, okay? Like, there are plenty of bigger fish to fry than fucking around with just trying to gum up the works on some stupid issue like this. So don't wait until the last minute to. These are the dumbest points to try to fight this battle on, right? You just don't need to be dumb about the stupid shit. Just like be smart about the things that are important and just take care of the things that can be easily taken care of. When you try to make the simple things a clusterfuck, you just look like idiots to everyone. You just annoy the court, you annoy the lawyer. Like everyone is just like why, right? It just looks stupid. You don't have any interest in looking stupid. It's not in your interest to look stupid. Do you understand? So, like, don't just make it simple. Just shoot off a 2 sentence email that says, you can go ahead and unseal my objection, or hey, I haven't gotten this notification yet. Could you please, um, you know, redact my address because I don't want that to be public, or, like, simplify this shit, okay? Um, it's not complicated. And do not email the court about it. Can I say that again? Like this minutia, this administrivia, this is not the court's job. The lawyers are hired and paid to handle this stuff. Okay. Um, so then that's for the in-person people. The other thing is that if you're just a class member who didn't file an in-person form and you want your objection unsealed, you have 10 days to notify them and to have it unsealed. Now, this requires that you send an email to that BLBG address, the same one that you sent your objections to, and just again make it as simple as you want. If you want your shit redacted, now this doesn't specifically say that you can redact your shit, but I would follow basically the same procedure that's in the C section, the section above that's like this little letter C. I would either tell them that you want your address or whatever redacted, but preferably what I would do is I would provide a redacted copy of it if you don't want anything fucked up. Like that's just what I would do because I like to have control over things that I can have control over. And so I would rather handle it myself than, first of all, you're going to have a much higher chance of making sure that it's done right if you do it yourself. The other thing is that when you do this, you should refer to the control number that is on that other document. So when you do this, again, you always want to try to make everything as simple as possible. I know that you like are trying and look, I get I do get that you have been dealing with a whole ton of shit and I do get that you have full-time jobs and that you don't have time to deal with this. I get that it's total bullshit that all of this is going on. Like I get that it shouldn't be this complicated. I totally get that. I don't mean to minimize that. I just I just also think that like there are times where um that the frustration turns into like a willful desire to destroy the process so that you like people lose sight of the fact that you're just making it worse. And I understand the frustration that leads to that kind of thing, but I honestly don't think that it's useful. I mean, I guess we could debate about that, but um it's just my opinion. So when you do, um, Yeah, I mean, look, you also don't have to object to this settlement. Like there are people objecting. Not every that's the whole point of a class action is that not every single person needs to be involved. Like the point of a class action is that other people are going to object on your behalf. Now, you can question whether or not people were like sufficiently doing that here, but you did have Rose Izzo step in with counsel. Someone asked earlier, is it too late for a shareholder to hire an attorney? No, it's not. I mean, you know, it's never too late to get counsel. No, you could no, it's not. Um, it's not too late for a shareholder to get counsel. With the practicalities of it are a different question. So um so I think that's look, I get that it's complicated. I get that it's like uh difficult. I get that it's a lot, but like you wanted to know what the deal was, right? So I'm just trying to tell you what the deal is. If it's too much information, then I don't know what to do. Like there's you either have no information or you have too much information. It's fucking Goldilocks, right? There's no y'all can't be pleased. So um basically, if you don't do anything, then your objection will remain sealed, but that doesn't mean anything with respect to whether or not the special master and the judge will consider it. They will all be considered by the special master and the judge. Now, I just want to be clear that just because the special master and the judge will be considering it, um, I don't think that you should expect that the report and recommendation or the opinion will actually like discuss 2,850 objections, like by name or something. I mean, that's just not practical, right? That doesn't make any sense. Um, so I think that you need to have realistic expectations about what it means to have your objection addressed. Um, I think all of the legal objections will be heard. I think a lot of the things are unfortunately beyond the scope of what this court can handle in its jurisdiction. And I'm sure that's upsetting to some of you. And I am sorry for that. But you need to also like understand what's really actually likely to be addressed here and what's really likely to not be addressed here. And the court has already made pretty clear that there are things that are just not appropriate for its jurisdiction here, some of which are the major things that you all are concerned about being the major issues of, that you have with this situation. So, um, that's the reverse split is inevitable. So is the reverse split inevitable? Um, I guess the question is, um, the settlement that's been put in front of the judge for approval is includes a reverse split because it's basically mathematically requisite for the collapse of the preferred into the common right now. Um, with the sort of architecture that, I mean, just the way that the settlement is drafted, it it the way that the settlement is structured, it requires the reverse split. That's not to say that it is necessarily in and of itself inevitable. However, what's presented to the judge for approval is the settlement as a package. Like I mentioned earlier, she can't go in there and say, okay, I've made all these sort of changes, like I've decided that, I approve this settlement, but without the reverse split, and then I just approve that and we're going forward with it immediately. What would, if she doesn't like something about the settlement? Now, I seriously doubt it would be that she would dislike, like the reverse split does not seem to me to be the thing that she would, in the settlement context, the reverse split does not necessarily seem to me to be the thing that she would be um, most preoccupied by. To me, there are other things that I think she could be concerned with about the value of this settlement, but the reverse split is sort of tangential to that. But if she didn't like something about the settlement, if she didn't like the reverse split, she would have to just reject this settlement and tell the parties to go back to the negotiating table or to go back to litigation. And a rejection of the settlement then would require basically a whole new round of notice, a whole new uh, a whole new a whole new go around the ring, basically. Um, And then the question is like, would they be able to come up with a settlement that didn't involve a reverse split? And so it's like it's an impossible question to answer because the question is just, I don't know, could you get AMC to ever agree to a settlement that didn't include a reverse split? And I have no idea because I don't know what's in their heads or what they would agree to or what their terms would be. Um, so it's it's hard, it's impossible to say. Like because it's not an answerable question in the sense that the court doesn't have control over whether or not the reverse split is inevitable or something like that. It's sort of like a what do the I mean, in one sense, I guess the that question is just phrased in a way that it's very difficult to answer. It's sort of an unanswerable question. The I think that probably the answer is no, it's not inevitable. Is the answer, but the answer is a lot more complex than just saying no, um, because that sort of makes it sound like that's misleading in the way that the question is framed. Um, but the I think the bigger picture that a lot of people are probably missing is just sort of what the process is going to be like if she rejects the settlement the first time, because the rejection of the settlement doesn't just make this whole thing go away, which is the other probably misunderstanding. And again, the rejection of the settlement just sends us back. It's like Chutes and Ladders. Am I showing my age? It's like Chutes and Ladders if you go back to the beginning of the board, or like, Monopoly, like go back, whatever. Like you just go back to the beginning of the this process. You don't just exit the game. Um, so if she rejects the settlement, there's another there's another loophole pathway potentially also that comes into play if she rejects the settlement. But the main thing is that rejection of the settlement is not like by any means the final. She doesn't reject the settlement and dismiss the case. That's not how it works. She rejects the settlement and sends the parties back to either litigate, which they're not going to do. They're going to just go back to settlement in some other form. They're going to try to appease whatever things she was dissatisfied with about the original settlement. And as someone says, the concern of bankruptcy for AMC and the concern of shareholders sort of receiving zero consideration for everything, getting zeroed out on their equity, if that's a real concern, then of course the court has to be considering all of these factors. So it's a delicate balance. And then there's all the people who think that that's not a real concern. And then there's people who think that that's a super real concern. And there's all sorts of vitriol and angst about whether that's a real concern. So everything's a fucking fight, right? But the point being, the court is trying to balance all of those stakeholder concerns in rendering the decision uh, justly, speedily, and uh, fairly, uh, and balancing all of those issues. So the other weirdness is that if 242D2 passes in the Delaware legislature and goes into effect on August 1st, it's unclear how that could interplay. It's unclear how that could impact the status of the case. It's not that it would be some easy off ramp for AMC, but it's unclear what kind of motions they might try to make about getting a new stockholder vote that might allow them to somehow, I don't know. I don't think it's actually viable. I wrote a whole Substack about it. I think I even put it outside the paywall. It's a long fucking story. It's incredibly complicated. It's it's brutal and it's a lot. Um, and if you live in Delaware, you should be concerned. You should be calling your legislator. Um, but you know, it's changing the rules of the game for every Delaware incorporated company. So they can't just pull out of the case, no, but it does give them, you know, like I say, some potential argument for shenanigans. I don't actually know that they will take it because they will be so exposed to more legal risk that way, and they do seem to want the kind of release that they could only get from the court in terms of their exposure. The kind of release that they get from a class action lawsuit is very beneficial to AMC because no, that this case would not be grandfathered in. It's amazing. The thing about 242D2 is it has what I keep calling like the anti-grandfather. It's like the opposite of a grandfathering clause. It's literally like every company in that's incorporated in Delaware is like force opted in. Um, it's bizarre. Um, so it's but the kind of release that you get when you're in a class action lawsuit like this is quite, I mean, the release that they're seeking in this case is quite broad. It's quite beneficial to AMC. That's why they're settling this case. That's why they want to settle this case because it covers all federal class action claims. It covers all claims relating to ape claims for AMC shareholders. It covers all sorts of things. And so then uh no, it's beneficial to AMC to get the release. So they won't necessarily be just running off to use the new statute because again, there's really valid legal benefits to getting the release. Okay. Um, a share recall. You're asking why I haven't covered a share recall. I don't, I don't, I don't know what legally I'm not aware of what. Do you mean a recount? Do you mean I don't know what a you mean canceling the ape shares? I don't know what that means or what it is or what you're spamming the chat about. Um, I don't know what it is. It's not a legal thing that is in my domain. So, I apologize. Uh it's not a thing that this court is going to grant. Um, so some people are asking if they should opt out of the lawsuit. I covered that earlier. There's no way to opt out of the lawsuit right now. If the court grants this as an opt-out settlement, there would be an opt-out period. It's highly unlikely that the court will grant it as an opt-out settlement, although it is a thing that could happen. It's very unusual in the Court of Chancery for there to be an opt-out settlement. Rose Izzo did argue that there should be an opt-out here. Um, but um, let's see. Apparently, I'm a crook because I don't know what a share recall is. Okay, well. Um, let's see. Yeah, the court is not going to rule on a share recall. I mean, like I said yesterday, I'm just here to tell you what's so. I'm not here to make a decision on um what that means. I'm just here to give you the facts so you guys can decide what to do about it. If you need a share recall, you need to figure out uh I don't know who can grant you one because it's literally not a concept that is a thing. Um, like you at least have to use a term that that I'm familiar with, uh, because yeah. Um, so I think that's answered most of the questions, unless you guys have anything else. I think that gets to the heart of the most important things. Look, the next big thing is the 21st. The report and recommendation comes out. Then you will have the uh, you'll have the till the 28th to file exceptions. But again, filing exceptions to the special master's report and recommendation is not just like shooting off a letter. It should be a much more formal process. If it's something that you think you're going to want to do, you should probably, consider hiring a lawyer, you should probably consider like at least getting really well educated on what your legal arguments are. You should probably not be doing duplicative work with someone else's objection. You should have, it should be something that like you were the original author of the objection and its legal arguments. Like you should not just be spamming the court with it's not just a thing to like show numbers at that point. It's really a thing to just express a particular legal argument. It's at the especially at that phase, it's really not about just like it's not about, how many exceptions can we file. It's not going to strength in numbers is not going to be the thing at that point. Um, so um, we can look at one more document. Let's see. Give me 1 second. Hold, please. Um, sorry. Almost there. Stipulation. Okay. Okay. All right. Here's the stipulation. Um, this document is available on the I've I've given you guys the FKS firm. If you go to fksfirm.com, they have the clearest and easiest link to get to all the AMC documents. Um, F as in Frank, K as in kangaroo, S as in Sam, firm.com. And then it's literally like visible to the human eye where it says AMC case documents. It's easily navigable. Just go there and then go down to stipulation and agreement of compromise. Um, then this is the stipulation. This shows you what is being released, what claims are being released. Okay, so in here, released defendants' claims, released plaintiffs' claims. Let's see. Released plaintiffs' claims. So Release plaintiff's claims. This is you guys. Section R. Um, Bottom of page 13. Release plaintiff claims means any and all actions, causes of actions, suits, liabilities, rights of action, debts, sums of money, covenants, contracts, controversies, agreements, promises, damages, contributions, indemnities, and demands of every nature and description, whether or not currently asserted, whether known claims or unknown claims, suspected, existing, or discoverable, whether arising under federal, state, common, or foreign law, or whether based on contract, tort, statute, law, equity, or otherwise, including but not limited to federal and state securities laws, that plaintiffs or any other settlement class member, one, asserted in the Allegheny complaint or the Munoz complaint, or two, ever had, now have, or hereafter can, shall, or may have, directly or representatively, derivatively, or in any other capacity that in full or part concern, relate to, arise out of, or are in any way connected to, or based upon the allegations, transactions, facts, matters, occurrences, representations, or omissions involved, set forth, or referred to in the complaints that relate to the ownership of common stock and or AMC preferred equity units, APE, during the class period, except claims with regard to the enforcement of the settlement and this stipulation. So what that means is that they get a release of all. Okay, if you're gonna keep spamming share recall into the chat, can you just please stay on topic? Like, you can go spam share recall into some other chat where I can actually talk about it. Like, someone can talk about it who knows what it's about. This release is covering all of those things. That the only thing that it doesn't cover is that last little clause, which is claims with regard to enforcement of the settlement and the stipulation. So that would mean, like, if you didn't get your settlement consideration, you would have a claim that you can enforce. So for those of you who are concerned that, you didn't get a postcard and that means that you might not get the settlement consideration, you don't give up your claim to having a right to enforce the settlement, presumably. But basically, you can read all those synonyms lists. It's like a thesaurus. So pretty much anything else that's related to anything that's related to ape, since the complaint is about the issuance of apes, then you basically have to, you know, that covers pretty much everything about that. Um, Someone's asking how come the court hasn't looked into shareholders not getting their postcard. I covered that earlier, but the court wouldn't like it's not the time yet. The court will handle the court. One of the things that the court will address at the hearing and then will rule on thereafter is the sufficiency of notice. I think it might be in here actually. Uh, um, that's one of the things that will happen after. Uh, Actually, I think it's in the notice. It, the One of the things that will happen at the hearing and that will be decided on thereafter is the sufficiency of notice and the whether due process was satisfied. So the affidavit was just submitted with the reply brief. That's why it was submitted, so that the court can consider it. The court will then discuss and ask about, any questions that the court has at the hearing about the postcard notice. But the court wouldn't be. She has other matters, actually, if you can believe it, on her docket right now. The time for her to ask questions and follow up about that is at the hearing. If she finds that notice was not sufficient or didn't satisfy due process, she would um, require renotice of the class. That in the Wanda case in AMC, actually, she found notice was insufficient for a different reason. That she found that the notice itself was actually deficient. It The form of the notice was deficient, so she required not that the way the notice was delivered, but that the content of the notice itself she actually found to be deficient. So she required that it was delivered again, but actually that notice only went out to record holders. It didn't go out to beneficial holders. So you can make of that what you will. Um, that was in an AMC case. But it's just that it's not the appropriate time yet for her to be concerning herself with making that decision. Um, okay. So, y'all are spammy as fuck. My God. Um, okay. Well, do you have any other questions that aren't about the share recall, which I currently have no information about, but I understand that I should look into it. Um, yeah, I know I need mods. I get that. Um, so I don't know if this live chat is going to save, so if you have anything that you think that I actually need to see, you could post it in the comments once this video saves, or if you want to say something actually useful, you could post it in the comments once the video actually saves. Um, and I understand that you're frustrated, and so if you haven't read the Izzo objection, the Izzo objection is the one objection that was submitted by an objector with counsel. It may be a little bit um, complicated, but it's, you know, an interesting read. It AMC has updated their page now with a lot of these documents, so you can find it there. They finally did. Um, so it does cover a lot of the it covers the opt-out right. It covers Izzo is actually asking, yeah, they did release the redacted Izzo objection. Oh, it's in that Thomas Curry exhibit. So so where is it? Oh, what? Are you fucking kidding me? Oh my God. They posted the one that doesn't have it in there. God damn it. These people. Oh my God. I'm sorry. AMC posted the version that doesn't have it in there. I swear to God. These. Hold on. I'm gonna find it. Oh my God. Just constant shenanigans. Why does it have to be this difficult? I'm sorry. Yeah, you're right. It's not sealed anymore, but they haven't posted the updated one. I'm finding it for you. I mean, it's available. I might have, hold on. I'm gonna find it for you. Ugh, Jesus. This should not be so difficult. This should not be my problem. Is the bigger point. Um, okay, let's see. Okay, here it is. How can I get this link to you all? Let's see if I can post it in my own chat without YouTube. First of all, it's gonna play my video as soon as I open this, but I'll try to shut it up. Uh, shh, shh. No, quiet, tab, mute. There we go. Okay. Can I edit video while I'm streaming, or is that going? Oh, wait, here I can say something. Well, that's a long fucking. Oh, the link is too long. God damn it. Hold on. I will solve this problem. I will sell this house today. I will sell this house today. I will sell this house today. There we go. Okay, I did it. I did it. Yay. I did it. There you go. There you go. Did you get it? Good. Okay. Um, I'll also edit the video in case this chat doesn't save because yesterday's chat didn't save, but I think I changed the setting in YouTube, but God knows if I did it right. Um, because I have no idea what I'm doing. I just learned all of this in the last 24 hours, so bear with me because I'm a total noob. Um, okay, so yes, there's that. In Yeah, no, it shouldn't be this hard for you either, of course. Definitely shouldn't be this hard for you. Uh, okay, so there is the Izzo objection. You should read it. It's quite good. Um, and it you got to read it in the sense of like this is an adversarial process now with Rose Izzo having counsel. Now it's basically AMC and plaintiffs versus Rose Izzo and her counsel. You've got to understand that those of you who are objectors may be aligned with Rose Izzo. It's still now it's David versus Goliath and Goliath. Um, so while you may think that the arguments sound strong, there is no, you should. I know that when I first started out as a lawyer, I would read one side's brief and be completely convinced that they were like absolutely going to win the case. And then I would read the other side's brief and be like, holy shit, those other siders, they're morons. Like, what are they? That was the dumbest thing they ever argued. And then I would read the reply brief on the third time around, and I would be like, what in the hell was I thinking? And then I thought those other guys were going to win. So it's like you have to understand that you aren't hearing like you have to go back then and read the reply, which is I can give you the link to the reply brief that addresses the Izzo objection if you really want the full picture of what the because the reply brief is addressing the Izzo objection And so you can't just read the Izzo objection and think like, oh, that's the end of the story. Um, you know, there's both the plaintiff and the defendant's reply brief. Here's the defendant's reply brief, and here's the plaintiff's reply brief. And then they both address, well, I think they both address, yeah, because they both address the opt-out issue. Because what Rose Izzo is arguing is that the opt-out, because the opt-out basically would allow the status quo order to stay in place indefinitely, that would mean that that apes would just remain a separate security uh, for basically indefinitely. Um, yeah, I mean the concept of Izzo taking over this class action, when I say David versus Goliath and Goliath, I'm not exaggerating. The chances of this happening are David versus Goliath and Goliath chances. Like this is I mean, David did beat Goliath, right? But like, it's a it's a long shot. Um, you don't know what's going to happen. That's why you fight the battles. But it's you just can't read one thing without reading the counterpoint, right? So the whole situation is pretty fucked. I mean, I'm not sure that I see a really fair outcome for everyone. There's there are a lot of ins, lots of outs, lots of what have yous here, dude. There's a lot of there's a lot of stakeholders here, a lot of different contingencies that are at odds, and a lot of risks to take into consideration, a lot of just a lot of factors. It's a hard case. So I think that, you know, well, you can read it and see what you all think, but I'm sorry that you didn't have it before, but there it is. Um, you know, there's also just a lot going on here. It's just a lot going on in this case. Okay, I think that's all. Those are my, I don't know that I really set any ground rules other than please help me clear up any misinformation about who I am and whether or not I work for the court, because I don't. I explained who I am and what my background is and why I'm here and what I'm doing, and you can decide whether or not you want to listen to the information that I have to share. Um, it's a good question about why the media isn't talking about this. I have a feeling that they're just going to be really late to the game on it, probably similar to the way that they were with GME. Um, I think that it's way too complex in the legal issues about it. You know, I was really dissuaded from getting involved in it when I was first, like, when people were first telling me about it, they were like, don't get involved in it, don't involve yourself in it. I mean, there's a lot of classism about it, honestly. A lot of classism about it. Um, uh, yeah, the media does stay out of court cases. I think there's a lot of factors. One is that it's a complex court case. One is that it's hard to report. The media is fairly terrible at reporting on court cases well. They pick up on them late. They don't understand things. They don't understand the significance of things unless it's spoon-fed to them. Um, I'm generally the one that spoon feeds them things like this, and uh, you know, I think that there's an impression about this you know, whatever group of people that retail is I don't know what else to say other than there's a classist bias. I don't know. I don't know how else to put it. I just think it's uh that's part of what it is. There's some highbrow, lowbrow kind of thing going on, and I don't know. That's why like it's I'm not I am not trying to pat myself on the back for being here. I'm just saying it's why people aren't necessarily helping you out. It's why um because there'll be people that I am friends with. There'll be people in my circles who think it's not cool that I'm doing this. Like there will be people who are mad at me for talking to you all about this. They'll think that I am like, I don't know, whatever. Someone said something like, someone tweeted at me about casting pearls before swine or whatever that fucking Bible verse is. Like, fuck that. I mean, that's so fucking rude. I just like it disgusts me. I mean, I fucking hate that. Fucking hate that mentality so much. And uh, it infuriates me that it fucking infuriates me. I don't know what else to say. Um, I don't know. I went to school. I went to an a fucking Ivy League law school, and I was, the only one there with that didn't have parents that went to an Ivy League law school or whatever. I was first generation. I was only not first generation college because my dad fucking went back to college and graduated like 2 fucking weeks before I did because I inspired him to go back to college and get his college degree when I went to college. And I just like I worked my ass off to go to law school, and uh, I loved it there. But like, I don't know. I'm probably a traitor to now the people that I uh like know, the people who whatever the like who are similarly educated to me and stuff. But fuck that. Like that someone has to break the cycle of just maintaining the information by it. Like someone has to make it stop. Uh someone has to make it stop. I don't know what else to say. Like um it's not working the way that it's working. And uh so this is what I can do, and that's why I'm doing it. So if you guys can help me by you know, uh just like I say, I don't need you to do anything except just like if you see people misrepresenting what I'm doing on here, just correct them for me. Do do all those lawyers in Wilmington really wear bow ties? Honestly, I don't spend that much time in downtown Wilmington anymore because the attorneys in downtown Wilmington are kind of annoying. Um, so uh, you know, I I do see what this case more broadly means to people. I also see what kind of uh, weight you're putting on the court that is like I, I want to be really real with you. Like it's in some ways unrealistic because you're hoping for things that are potentially just literally out of the reach of the court. And so I don't want you to shoot the messenger, but like I also want to be real with you about what's possible and what's not. And then you all have to like, I want you to be present and conscious to what is going on because I know is that you will be trodden on if you have no idea what's going on. And I don't want that to happen. That like hurts my heart to see. Um, it's just, it's not okay. Um, so that's the best I can do, is to just share with you the facts and tell you what is going on. Um, and thank you for understanding uh, that I'm just a weirdo who gives a shit for some reason. No, I'm weird like that. And I don't know. I was just born this way. Somehow it got shaken out of everyone else during law school or something. But not me. I didn't give it up. I appreciate that you want me to be your lawyer. I don't actually think that that's like the best use of my uh, resources, because I'm not sure that that's like the I don't think that I'm not sure that this is, I think probably Rose Izzo's counsel has taken up the mantle that there is to be taken up here. Like I don't know that there is another. I think that the court is going to do whatever is the the best and right thing. I think that for me to just provide the legal information that I do to you all and just out into the world and to analyze the case from an objective perspective is the best use of my skill set. Um, I'm pretty sure that's the that's the best use of my resources. At this phase of the case, it's just not like this is not a case that I would want to like take up litigating. It is, I would never have brought this case in the first place. So to like to take it up at the middle of where it's at right now, I mean, there would be like, there's a million, I mean, there's a billion like real world considerations, but just like, oh my God, like there's a million reasons why not. But like, there's so many things that are not, um, there's a lot of reasons. But one is that the playing field is sort of like covered here. I think that the objectors have done a good job. Like the pro se objectors covered a lot of the issues. Rose Izzo covered basically the main issues, and then every other issue is sort of like the court is I think going to address the main merits objections to the settlement. And so I think that my skills are best used to sort of just keep you all objectively informed about what is going on instead of being some biased advocate on one side or the other. So that is my position, that I am not your lawyer, but I am your friend. Um, Yeah, I think the release is an issue, and I do think that, Rose Izzo's counsel at least raised it sufficiently. I think that at least sufficient such that the judge has to consider it thoroughly. You know, the um, the the federal securities law release is something I think Zern will give real thought to, and the ape claims release is something I think that Zern will give real thought to. So, um, I think that's all I have for now. I appreciate the fact that I have no idea who are who and what are what and who are yes tubers and no tubers and medium tubers and large tubers and um but I thank you all for being here, and if you have other things that we didn't cover, I would recommend that you actually go read some of the documents. I know they're hard to read, but and I will post the oh, let me post the link to the again, you can just like when the Substack thing pops up and says, "Do you want to subscribe?" You just say you can either enter your email address and say that you want to add yourself to the list. That's free, and then um, and you will get notifications of all the pre-paywall content, and then you'll get notifications of whatever the like you'll get the pre-paywall part of the paid post, but you don't have to subscribe. And like I say, you probably don't want to pay to subscribe if you're just here for AMC, because that would be, I don't think it's probably, I don't really want you all subscribing and then unsubscribing because then I'll just get my feelings hurt. It's just not worth it. I'm not here to show my newsletter. I'm here to tell you that like that post is free and it's about the 242D2 changes in Delaware. And if any of you are Delaware residents, you should seriously consider looking carefully at that post, even though it's long and winding. And I had to write it in a very folksy way because I'm probably pissing a lot of people off by writing it. So um, I have to be a cute, wonky, funny, ditzy girl who's just thinking about things because otherwise I'll make people really mad. So anyway, just me being me. Um, the Have a great night, everyone, and thanks for listening. And I will post the links in the description so you have them. And I will post the Izzo objection again here now. Okie dokie. Bye bye. Somehow, if I can figure out how to end the live stream. Wait, let me do the fancy ending so that it's pretty. Oh, now I gotta wait for it. Whoop, I didn't press the button. God, I'm such a noob. Okay, there we go. Now I can officially ending soon. Wait, now I gotta do the offline one. Huh, this is so fancy. So fancy. If I say I'm offline though, I should probably stop talking. Bye.